The Constitution spells out the model of separation of powers in the first three articles of the Constitution. It also spells out how checks and balances function to protect the freedoms of American citizens. Now let's see this system in action by examining some real events from American history. Let's take it all the way back to the early 1800s. President Thomas Jefferson had just taken office, and he has some problems with several officials that his predecessor, John Adams, appointed before the end of his term. One of them is a man named William Marbury, who Adams made a justice of the peace. Jefferson tells his Secretary of State, James Madison, not to deliver Marbury's commissioning papers, which basically means Marbury can't start his new job. Marbury takes his case to the Supreme Court. He believes that the Judiciary Act of 1789, a law passed by Congress, gives the court the power to order Madison to deliver the commissioning papers. So what does the court decide? The court, under Chief Justice John Marshall, agrees with Marbury that it was illegal to withhold his papers. However, they also find that they themselves do not have the authority to compel Jefferson or Madison to act, that it's beyond the scope of their power as outlined in the Constitution. The Supreme Court declares that the Judiciary Act of 1789, the law that Congress had passed giving them that kind of authority, is unconstitutional and therefore null and void. Looking back, this was an important moment for the Supreme Court. The case established that the court had the power to throw out laws passed by Congress that they found were unconstitutional. This power is known as judicial review, and it's a big check that the court has over Congress.
All right. So that was some drama early in our nation's history when the authority of the Supreme Court hadn't been challenged or used as much as we're used to it now. You know, the Supreme Court is very powerful. If the Supreme Court makes a decision that's not popular, we're either stuck with it, they can reverse themselves like they did with Plessy versus Ferguson Board of Education, but that's rare and it can take, as you see, a couple generations. Or a constitutional amendment can be passed but like I said, it's very difficult for that to happen. You know, it's not just like Congress can go vote. Congress has to vote, and they need a supermajority, so 2/3 of each house. Then it's got to go to all the states. All the states got to put aside everything they're working on and ratify a constitutional amendment. And they need 3/4 of the states to approve that. So that's an interesting check and balance that we have. Now, when it comes to the power of the Supreme Court, there's basically two schools of thought when it comes to how the Supreme Court should behave and what kind of role they should have. So there's the strict constructionalists, okay, which also is known as judicial restraint. So that's more of a conservative viewpoint that the Supreme Court shouldn't be making a whole lot of new law. We should leave that up to the legislature, and the Supreme Court should merely be interpreting the law or interpreting the Constitution and whether laws are constitutional. The other school of thought has to do with judicial activism. So there's, you know, a more liberal point of view that the Supreme Court shouldn't just wait for oppression to occur for generations. And if they believe that something is right, they should get a majority and change the law of the land. So, and what happens is you've got a balance. So you've got judges that are appointed over the years and from both parties, and you sort of have a balance between those two schools of thought. And some are more very conservative. I mean, I can't imagine how you could think that you should apply the laws about guns, for example. You know, the guns back in 1789, the arms that were available to people are very different than the kind of arms that are arguably available to people in this day and age. I mean, everyone should have a nuclear weapon? It doesn't make any sense. So obviously there's some amount of activism that judges have to do, a certain amount of evolution that has to happen, but that's just one example. All right, now I carry a copy of the Constitution with me back in the day when we used to go to court all the time. And mine's a little in tatters, but I started doing it in part because there was an attorney in Ithaca named Ray Schlatter. If Ray's watching, I'm very flattered, but I'm sure you're not. And when I saw him in court one time, I went over to him and I said, hey, you know, I carry a Constitution with me like you do, because I saw that you did it and you have a reputation for it. So he actually autographed my copy of the Constitution that day. And it says, it's hard to read, but it says, Kevin, may this always be your first book. And then that's his signature, Ray. And what he means by that is, you know, I have all these books behind me. Figuratively, I look at them on the internet, or I occasionally will grab a book and use it. And he's saying, always start with the Constitution. And I think that's a good point, because it is the bedrock of all U.S. law. And as a business person, you should look back to that too. You should be familiar with the rights we're going to be discussing in this chapter, and so on. We're going to keep coming back to them. And I'll tell you, especially when I'm really desperate and I can't think of a good law to help my client's argument, I will always bring up the Constitution, and we'll revisit that idea in a bit. All right, the first section here in 4.2 that they dive into in the chapter is the Commerce Clause, which is Article 1, Section 8, Clause 3. And that's the idea that the federal government has jurisdiction and can make laws regarding commerce. And that makes sense because, you know, when the states were getting together and they want to apply this new government, I mean, the government's, one of its most important powers is going to be to make sure that commerce can happen among the states. And that's, and it helps the economy. It's a forward-thinking idea at the time. And one case that illustrates that is you've got Hammer versus Dagenhart in 1918, which was reversed not too long later. But they really believe that, you know, laws that restricted commerce were unconstitutional. And here you had a law that had certain restrictions on child labor. And I think these days it's like, well, duh, we don't want children working in our factories or working, you know, in oppressive conditions or working too long. But in 1918, the Commerce Clause sort of was applied and made that law unconstitutional. So that was changed shortly later, but it's just an important one from history. So then the book goes into a bit of history here. We've got the New Deal. These days we hear about the Green New Deal. Back then, this is just the original New Deal. And basically you had Franklin Delano Roosevelt, the longest serving president in US history, who had to deal with the Great Depression and World War II. And basically were improving conditions in with the economy and with certain protections that the federal government can provide for its citizens. We've got the substantial effects doctrine, and I'm going to play another video. This is for another case in front of the Supreme Court, and we'll be right back.
Article 1, Section 8 of the United States Constitution, popularly known as the Commerce Clause, grants Congress the power to regulate interstate commerce. Congress has used this power to regulate commercial goods, products, activities, and travel between states. In the modern era, the United States Supreme Court has interpreted this power broadly, allowing Congress to regulate in-state activities that have a substantial economic effect on interstate commerce. In the 1960s, Congress used its Commerce Clause power to combat racial discrimination by passing the Civil Rights Act of 1964. Congress passed the act to prevent discrimination on the basis of race, sex, religion, or national origin. Title II of the Act granted a right of equal access to places of public accommodation that affect interstate commerce, including hotels and restaurants. On the same day in 1964, the court issued two decisions that addressed challenges to Title II of the Act. In Heart of Atlanta Motel, Inc. versus United States, the court upheld the constitutionality of Title II as applied to hotels. Then, in Katzenbach versus McClung, the court turned its attention to restaurants. Under the Act, a restaurant affects interstate commerce if it serves interstate travelers, or if a substantial portion of its food comes from another state. Ollie McClung owned and operated a local restaurant called Ollie's Barbecue in Birmingham, Alabama. Ollie's Barbecue was located next to an interstate highway, and 46% of the food served at the restaurant came from another state. Since its opening in 1927, Ollie's Barbecue had refused to seat and serve Black people. This violated the right to equal access under the Civil Rights Act. McClung filed a complaint against the federal government, which was represented by Attorney General Nicholas Katzenbach in the United States District Court for the Northern District of Alabama. McClung argued that the act was unconstitutional as applied to his restaurant, which had virtually no effect on interstate commerce. The district court agreed, finding that there wasn't a close enough connection between discrimination at Ollie's Barbecue and the food purchased by the restaurant in interstate commerce. Katzenbach appealed the district court's decision directly to the United States Supreme Court. The issue on appeal was whether Congress had exceeded its power under the Commerce Clause by applying Title II of the Civil Rights Act to local restaurants. Writing the majority opinion, Justice Clark held that the court must uphold legislation enacted under the Commerce Clause when it finds that Congress had a rational basis for concluding that the regulated activity substantially affects interstate commerce. At the lower court hearings, evidence showed that Black people spent less money in areas where racial discrimination was widely practiced. Also, restaurants that refused to serve Black people had fewer customers and thus bought and sold less food through interstate commerce. Finally, Black people were less likely to travel between states due to racial discrimination in restaurants. Therefore, based on this evidence, the court held that Congress had a rational basis for concluding that racial discrimination in restaurants had a substantial effect on interstate commerce. Title II of the Civil Rights Act, as applied to McClung's restaurant, was a constitutional exercise of Congress's commerce power. The district court's judgment was reversed. Justice Black concurred. Black wrote that the Commerce Clause, in conjunction with the Necessary and Proper Clause, gave Congress the power to regulate local entities that burden the flow of interstate commerce. Justice Douglas also concurred. Douglas believed that Congress's power to enact Title II came from both the Commerce Clause as well as the 14th Amendment's Equal Protection Clause. Douglas argued that basing the decision on equal protection grounds would have had a more definitive effect because it could end discrimination in all places of public accommodation, regardless of their effect on interstate commerce. Finally, Justice Goldberg's concurrence found clear authorization from both the Commerce Clause and the 14th Amendment. Goldberg emphasized that the purpose of Title II wasn't to regulate commerce, but rather to protect human dignity against discriminatory conduct. Katzenbach versus McClung is significant for finding that Congress could use its commerce power to combat racial discrimination in places of public accommodation. This decision also promoted judicial deference to Congress's power under the Commerce Clause.
All right.
Under traditional tort law, a landowner's duty to a visitor depends on the visitor's status. A landowner owes the highest duty of care to business visitors, but a limited duty to trespassers. In Hines versus Webster County, the Nebraska Supreme Court considered whether there might be another way to assess a landowner.
We're not ready for all that yet. We'll get there in chapter 7. When we talk about torts, back to the Constitution. So, I think that was an interesting crossroads in the history of the Supreme Court when we're talking about those two schools of thought, judicial activism on one hand being sort of the liberal application of Supreme Court power versus the judicial restraint, also known as the strict constructionalist point of view. And, the defense in that case Ollie's restaurant, Ollie's Barbecue. They won at the lower court. They were able to convince that court that, hey, we're just minding our own business here. We're not advertising for people in other states. We're just a small little restaurant minding our own business. And the court looked a little deeper. They said, you know what? You have an effect on commerce, a substantial effect. Almost half of your supplies come from other states. So that's how they were able to use the Commerce Clause to make their practice, have jurisdiction over the practice, that not to only serve white people. All right. Next, we're moving into the Dormant Commerce Clause. And basically, we've been talking about the idea of commerce already. The cases discussed here in the chapter have to do with states' police powers, if they're not conflicting with federal law. So there's a balance there that states, again, we're talking about federalism and what kinds of laws states can pass. The first case is Cassell versus Consolidated Freightways. And that was a case in Iowa involving a law that Iowa made saying that on our roads in Iowa, you cannot have these big long trailers with more than one trailer. Okay, so I think of Iowa as a state that maybe a lot of trucks have to drive through, and so but they said, to protect the safety of our citizens, we don't want that on our roadways. People are getting cut off, they're getting taken off the road by these big trucks. We're making a law here. And the way to get around that is you can drive around Iowa, but if you see where Iowa is situated, it can be hard to find a way around that. Or they have drivers waiting on one end of Iowa, and they can hook up your truck and pay a shuttle service to take one of the trailers to the other end. And what the court decided was that infringed on commerce. You can't have a law like that in Iowa. So that law was illegal because it restrained commerce too much. Another case is Oregon Waste Systems. And that case involved a landfill in Oregon and a law that made it more expensive for out-of-state waste to be brought to the landfill in Oregon. And again, there's no rational basis. We learned that in the video that there has to be, and it infringes on commerce. So that law was ruled unconstitutional. All right, we've got the preemption doctrine or the supremacy clause. And basically, that's where Congress can declare exclusive regulatory authority. So we're going to get to administrative law in chapter 5 in the next chapter. But, basically, they can either declare it or it can be implied. So I brought up nuclear weapons earlier. Nuclear Regulatory Commission is going to be the national body under the government to regulate nuclear activity. And so states aren't allowed to have their own commissions there. Now, Congress can also declare minimum standards, allowing states to have more restrictive standards. So you may have heard of the California emissions standard, and that's because the United States had their own standard. California had a larger pollution problem that made it politically popular to make a law with lower standards, and that was allowed back then by Congress. All right, we've got sort of business in the Bill of Rights. There's I talked about in chapter 3 long arm statutes. So a court in one state can reach in and get jurisdiction from another state, from someone there. And the example in this chapter is Burger King versus Redzewitz. And Redzewitz bought a franchise, and then I think he was in Florida, and he wasn't able to keep making payments to Minnesota, where Burger King was based. And he had never been there, but by having that contract with a party in the other state, it was ruled that they could reach down and get jurisdiction. They could sue him for the money that he owed the franchise. Let's see. Well, and we've got the concept of states' rights. So that's sort of the opposing viewpoint or argument or balance between federalism. So, when there's arguments for states' rights, those are there, but it's not simple. We know we had a civil war. I'll get to that in just a bit. All right, when it comes to the Bill of Rights, we're going to start with the First Amendment. So we talked about this in the first class when we talked about introduction to the law. And, the First Amendment is, you think of the freedom of speech, the freedom of assembly, the freedom of to exercise religion, to protest. There's a limit on rights, though. Now, Oliver Wendell Holmes, who you should be familiar with by now, only because his picture is right there. This is a portrait of Oliver Wendell Holmes. And you may have heard this saying, but it is illegal to yell fire in a crowded theater. So the comedian Demetri Martin said, so if there's a fire, please yell something else instead, like flames, smoke maker, bad hot. So obviously if there's a fire, you can say fire in a theater, but that is a famous quote by Oliver Wendell Holmes, that you can't say fire in a crowded theater, because if you're just doing it for kicks, you can easily cause someone to be trampled to death. So, because people would panic if they heard that, and they would want to be the first one out, because there'd be a stampede, and there's limited exits, and that people want to save themselves, they end up hurting each other. So that's the idea, is that there's a limit to freedom of speech. And it comes into play with protests a lot, or with maybe if you think of political cartoons or something. If someone's very offensive toward someone else, there might be limits on their constitution, or on their constitutional right to freedom of speech. So you can always imagine something like a crowded theater and someone saying fire. Well, you don't have the freedom to yell something like that and create a danger to everyone else. So there's limits on that. All right, now, most recently we had a case, it's about 10 years ago now, Citizens United versus FEC. And it's at the end of the chapter, but since it has to do with the First Amendment, and it has to do with business and the intersection of business and the First Amendment, I'm going to play a video now about that.
Citizens United versus Federal Election Commission declared unconstitutional a portion of federal campaign finance law that prohibited corporations from spending money to purchase speech that mentioned a candidate for federal office if that speech was broadcast within 30 days of a primary or 60 days of a general election. Basic premises of election law at issue in Citizens United was whether the First Amendment prohibits the government from making distinctions among types of speakers. In particular, the question was whether corporations have a right to speak independently of campaigns and to use their general corporate treasury funds to produce political speech. The court's holding was based on the principle that the First Amendment forbids the government from drawing distinctions among speakers. Some people sometimes claim that Citizens United permitted corporations to contribute to campaigns. That is incorrect. The case did not involve contributions at all, but rather independent expenditures, and the court did nothing to undermine the complete federal ban on corporate contributions. Citizens United was a nonprofit corporation that produced a documentary critical of Hillary Clinton, who at the time was a candidate for president. Citizens United wanted to distribute the documentary and to advertise it. Because Citizens United received some money from for-profit corporations, its spending money on speech mentioning Mrs. Clinton violated the ban on corporate spending in elections. The Supreme Court pointed out that the documentary and advertising would unquestionably have been constitutionally protected if engaged in by individuals. The court therefore had to determine whether the corporate nature of the speaker stripped the speech of the protection it otherwise would have had. The court held that the speech was equally protected regardless of whether the speaker was a corporation or an individual. The effect of Citizens United has not been as large as some people anticipated. Few corporations have been willing to devote large amounts of money to spending in political campaigns. It has, however, led to the proliferation of the so-called super PAC, an organization that collects and distributes political contributions. A super PAC differs from ordinary PACs because, after Citizens United, it accepts contributions from corporations. But because we still have the ban on corporate contributions to campaigns, a super PAC cannot take its funds and give them to a candidate. Rather, a super PAC can collect funds from anybody, including corporations, but the super PAC must spend those only on independent speech. Citizens United has been criticized for placing restrictions on the government's ability to limit the effects of corporate power. On the other hand, people who consider themselves to be protectors of free speech look at Citizens United in a much more positive light and say that it stands for the proposition that the government should not tell us what kind of speech we can produce or what kind of speech we can listen to.
All right. So that's a controversial case if you can't tell or you haven't heard of it before. But that's sort of a conservative viewpoint of that case, pro corporation, I would say. But I think it's worth learning some different viewpoints about that, about corporate free speech. As a business person, you can see the trade-offs, and I think they actually do a pretty good job of giving it a balanced explanation. At the time, when I was paying attention to the arguments, it sounded like the sky was falling with that decision. But so I watched a few different ones, and I thought that one was pretty concise and balanced. Okay, moving on to the Fourth Amendment. I think it's the next one that affects business the most. And there's a lot of application. You hear about it in criminal law, which we'll cover in Chapter 6. But just generally, people associate the Fourth Amendment with the right to privacy. And there is no right to privacy in the Constitution. You're not going to see that word in there. What you have with the Fourth Amendment is the right against unreasonable search and seizure. So the government shouldn't engage in unreasonable search and seizure. And, when the Constitution was written, that may have seemed, search and seizure may have seemed more like something that was regularly experienced by people who lived in the colonies under British rule. So you had redcoats riding around, and they could simply shake you down or enter your dwelling and see if you were starting an insurrection against the government. They were pretty paranoid about that. So our framers of the Constitution decided that we needed a law against that, and that's the Fourth Amendment. And we'll see that related to business because there's a balance when you have a business. You may not want everyone to know your business. If you have a secret recipe, and you don't want your competitors to know about it. Well, there's a balance between, people who have allergies, or if an administrative agency wants to test temperatures in your kitchen, there's a balance between the public interest of that, health and safety of everyone, and then on the other hand, the protection that the government wants to give business people and intellectual property. So you have a right to the privacy of a recipe, or the formulation of a vaccine or another pharmaceutical, or a business model, maybe how you do a certain type of transaction that can be proprietary, or it can be intellectual property. On the other hand, there's a balance with the Fourth Amendment and the right against unreasonable search and seizure. So it doesn't say there's no such thing as search and seizure by the government, but if it's unreasonable, then it's unconstitutional. So we're always looking at a balance, and I bring up that word reasonable, and I can't tell you how many times a day lawyers and judges think about the reasonable person standard. Who is a reasonable person? I think most people think they use themselves as a gauge for that, which obviously isn't always agreed. Moving on to the Fifth Amendment. The Fifth Amendment has some key principles like procedural due process. So this is the one that I am finding myself always bringing up, whether there's due process. And if I object and I don't necessarily have a particular law or precedent in mind, I say due process, and I protect my client's rights if something's about to happen and I want to stop it from happening, or I want to stop it from happening later, on appeal or whatever. Bring up due process. We've got the takings clause, which covers eminent domain. Okay, so think about infrastructure like roads and telephone lines and sewer pipes going through, and all those things that we like to enjoy, the modern conveniences that we have in our lifestyles. Well, not everybody's happy when it's in their backyard. So, if the telephone company, the internet company wants to put some wires from point A to point B, or they want to build a road from A to B, and it cuts in front of your property, and maybe you live out in the country and you spent a lot of money on a piece of property because you wanted to be far away from busy roads and things, but the government's telling you this is where the thruway is going to be, the new thruway. So imagine all those people along the thruway that lost their land and lost their dreams of what they wanted to do with that land. That's eminent domain. So basically we say that the government can take property if it's for the greater good. However, we have to compensate the people who they're taking it from. Now, if you're a subject of eminent domain, you're going to say there's no way that, $1,000 is going to make up for the thruway being in my backyard. But that's the balance here, and that's covered in the Fifth Amendment here. And they have to have some due process. So usually you'll get a notice that the government wants to do that. There'll be a hearing about it. And as long as the government gave due process, they're generally, the precedent is that they're going to be allowed for the public good there. And substantive due process. So there's minimal judicial scrutiny. If there's no rational government purpose, then, obviously the government can't take things in eminent domain under that standard. But, they're looking at economic legislation, employment relations, other business affairs. When there's heightened judicial scrutiny is when they apply the standard and an action will be invalid unless it's narrowly tailored to a significant government purpose. And then fundamental liberties include those that are enumerated in the Bill of Rights, those that are essential concepts of freedom and equality in a democratic society. So we talk about personal autonomy, things like that. And that's where, we don't have the word privacy in the Constitution. But here again, the Fifth Amendment is sort of going to apply that standard, feel like there's some right to privacy. And we'll study some cases like Griswold versus Connecticut. We may as well talk about that one now. It's at the end of your chapter, but we'll talk about it now. And that's a case from 1965. In Connecticut, you had a law at the time where any types of devices or anyone who talks about those devices or methods of birth control were illegal. So you had the like Planned Parenthood, the executive director there and a medical director there, and they were given fines for either selling or maybe supplying contraceptives to people. And those laws were seen as old. I mean, times were changing. Contraceptives were seen as more valuable to more people at the time. And the Supreme Court ruled in Griswold versus Connecticut in 1965, 7-2, so pretty overwhelming majority, that the government can't get that intrusive. I mean, they're essentially in citizens' bedrooms if they're saying that people can't use contraceptives. So that led to some other rulings, including Roe v. Wade, which protects women's right to an abortion generally. And, very controversial issue. We have a different Supreme Court. We've got conservatives talking about maybe revisiting that. You've got these sometimes absurd abortion laws that are being passed and they're being struck down by the Supreme Court. But there's obviously still a large amount of the population that believes that the government should be able to enforce laws that stop abortion. So I think that'll continue to be controversial. It'll always be something that we can teach about. All right, moving on, we've got the 14th Amendment, and that's the last one we're going to highlight in this chapter. But the 14th Amendment has to do with due process and equal protection guarantees. And we got to go back to the Civil War, and the 13th Amendment, banned slavery. And now you had sort of people being treated differently in different states. And to stop that from happening, they made the Equal Protection Clause. And the very basic definition is that all people are equal under the law. So, the Constitution was imperfect in that it allowed slavery, obviously. And you couldn't just ban slavery. There was obviously some other residual problems that even back then they could foresee. So we had the 14th Amendment, and that's what you want to know about the 14th Amendment. Getting into some cases here I guess you need to know a little more about the 14th Amendment. We talked about, so states treat citizens from other states with due process. That's sort of the meat of the document, but it's been boiled down basically to equal protection under the law. And that's where we get the ruling in Brown versus the Board of Education. So we're taking it a little backwards, but the whole study of business law is cyclical, and you kind of have to take a little bit and maybe look at it in a different way later in a different context. So that's what we're doing here. We've got different standards that the Supreme Court will consider. So we've got minimal, and that has to do with economic or social relations. And laws are usually upheld if there's a rational basis. So it's presumed valid if rationally related to a legitimate government interest. The next standard is intermediate, and that's generally deals with gender. So there are sometimes upheld. Now, I think that standard is evolving with, the trend toward feminism and equality. Then we have the strict standard, which is anything having to do with race, ethnicity, or other fundamental rights. And a law that seems to discriminate that way will almost never be upheld, okay, unless there's some kind of compelling need. One example that comes to mind is maybe, if a religion has you have to cover your face, and maybe there's a law that if you walk into the DMV, you have to show your face. So that could be discriminatory against a religion where you can't remove that covering. But if there's a compelling need, there could be an exception to that under even the strictest scrutiny. All right, the cases at the end of the chapter, I talked about Griswold versus Connecticut already. And the next case is Wickard versus Filburn. That's a case in 1942. And so you've got coming out of the New Deal that we talked about earlier with Franklin Delano Roosevelt, the federal government's getting more and more powerful. Administrative law is gaining traction. And you had a law that basically happened because wheat prices had gone crazy. I mean, people were overproducing wheat, so it drove the price down. And large companies maybe were doing well, and other companies were suffering because the price just dropped dramatically. So we had some government regulation of pricing, and that was controversial to begin with. People thought, no, it's a free market. It should be able to do what we want. But again, we're always talking about balance when we talk about the study of business law. And that's what they had in creating the Agricultural Adjustment Act. And that was 1938. So Filburn was a farmer in Ohio, and he didn't have a huge farm. He just had some cattle, some cows that he milked, some poultry, some chickens that he got eggs from, and then he had a wheat farm. And he mostly used the wheat to feed his livestock, but he did sell a little bit in season to some known consumers. He was not putting the wheat into the general interstate commerce. So he would be able to trace all of his wheat, where it went to, where it was consumed, and he could prove that it wasn't affecting the interstate commerce. So he thought that law, as applied to him, he had to pay. So he produced more than he was allotted under the act. So the act sort of rationed how much wheat certain farmers could grow based on how much acreage they had. And he was fined 49 cents a bushel for overproducing. And he sued and said it was unconstitutional. And even though he could prove that it wasn't affecting interstate commerce, it was only going to locally, his wheat was only going locally, either to his own farm or to some local sources. The Supreme Court reasoned that, and in fact, he won at the lower court. The Supreme Court reasoned that even though he was keeping it local, he was still affecting the overall price of wheat. Him, and not just him, but people like him, if they give a pass to people who could trace where all their wheat was going, they would still be affecting the price of wheat. And that was the purpose of the law. Okay, so the purpose of the law was to regulate the price of wheat. And when it comes to economic and social relations, we're going to apply the minimal standard, as I talked about with the 14th Amendment. And so he lost his lawsuit in the Supreme Court. All right. Let's see. Cassell versus Consolidated Freightways. We talked about that. The next case, I'm just going to introduce you to an old commercial. I'll be right back. So we're going to take a little commercial break.
This is our factory. and one of our best workers. We take the sun, clear glacial water, and deep volcanic soil to create a product that will surely make you healthy and perhaps even wealthy and wise. Fresh country apples from Washington State, the original health food.
All right, well, apples have been causing arguments since as far back as we've got writings. We've got in Genesis in the Judeo-Christian scriptures, we've got arguments about apples, who started what, and all of the evil things that happen in the world according to that. Sometimes lawyers say, well, you're comparing apples to oranges, and so classic subject of argument. And in this case, this is Hunt versus the Washington Apple Advertising Commission, and that's in 1977. And basically you had the state of Washington producing 30% of the apples nationwide, and they have a great reputation. They're obviously investing a lot in their commercials over the years. They're investing a lot in grading apples and issuing them to the public with a grading system. And the USDA, had already had a system, and the Washington system basically said, well, that's nice minimum, but we're very proud of our apples in Washington, so we're going to enhance our standards. And then North Carolina was getting these apples from Washington, and they wanted to promote local apples there. And so they made Washington abide by their standards. And so that made it difficult. It was extra burdensome on Washington. It was extra expensive for them to market and sell apples in North Carolina with their weird standards, according to the Washington defendants in this case. So the court ruled that it was, the law didn't have a rational basis, so that's sort of the lowest standard, which, we're applying here for economic issues. And Washington, their standards were already much higher than USDA. So to impose on them the North Carolina arbitrary standards were found to be unconstitutional and against our desire to promote commerce in the country. So they lost that case, and Washington apples won. So how about them apples? All right. The last case is Citizens United. We watched a little video about that. We're probably going to be discussing that ongoing in the class. And that does it for Chapter 4 on the Constitution. But we'll be continuing to talk about the Constitution for the rest of the class, because it is the most important law in the United States. It's the bedrock for all the laws, and it's very close to my heart. Bye-bye.